Good evening. Today is November the 8th, 2023, and the Board of Appeals for the City of Gaithersburg is now in session. Okay, calling the meeting to order. The first item on our agenda is the approval of the October 11th meeting minutes. May I have a motion for the approval of these minutes?
Not yet. Couple of corrections.
Oh, well, we're going to do the motion, and then we'll have discussion, and that's where we'll bring up the corrections is my recommendation for Robert's Rules of Order.
Okay.
Is that okay?
That's
okay. So
fine.
Can I call for a motion to approve the minutes?
I make a motion to approve the minutes.
I'll second.
Discussion.
Second page, under the public hearing for BOA 9648-2023, the second paragraph, super minor point where it says the sign location has been moved. I guess it probably should be had been, not a big deal.
Okay.
But the next sentence, it refers to Mr. Mukherjee, not Ms. Mukherjee, which actually I think is relevant.
Okay,
Yeah.
thank you.
Yeah. So the first one's just a minor nit, but the second one's relevant.
Yep.
Yeah.
Okay.
That's all I got.
That's all you got. Okay. Any other further discussion on the minutes? Okay, so I'll call for the vote. All those in favor of the approval of the October 11th meeting minutes, say aye. Aye. Those opposed? Okay, the motion passes for the approval of the minutes 5-0. All right, the next item on our agenda is the public hearing for the variance BOA 9662023. And this is a variance request for a 25% lot coverage limit for the expansion of an existing building at 45 West Watkins Mill Road in the I-3, which is Industrial Office Park Zone. And at this time, I'll ask Caroline Seiden to go ahead and present the official record.
Good evening. This is a public hearing on Board of Appeals case BOA 9666-2023. The hearing was published in accordance with the requirements of the city charter and code on the city's website, and the property was properly posted. At the present time, there are 17 exhibits in the record files. They are referenced in an exhibit list in the files. The individual exhibits may be reviewed during the course of the meeting or in the Planning and Code Administration office during regular business hours at City Hall or on the city's website. Any objections to the receipt of any exhibit should be noted prior to the closing of the record. Otherwise, they will be deemed received in evidence. The application requests the variance of the 25% lot coverage limit for the expansion of an existing building. The property is located in the I-3 Industrial Office Park Zone. Pursuant to Section 24-148 of the City Zoning Ordinance, not more than 25% of the net lot area of any lot in an I-3 zone shall be covered by buildings, including accessory buildings. The property is located at 45 West Watkins Mill Road, Parcel E, in the Bennington Corporate Center, Gaithersburg, and it is shown on the aerial. The parcel in question is Parcel E with the 3 buildings shown in the center. The whole parcel that is part of the Bennington Corporate Center is just south of the CSX railroad tracks, which are just off of the aerial, to the west of Watkins Mill Road and just north of Clopper Road, which is also off of the aerial to the just south of the parcel. Here representing the applicant is Stuart Barr, so I will introduce him and have him present.
Okay, so before you introduce Mr. Barr, I just wanted to bring up to the board as a reminder that we as the board usually deal with different types of cases. We can deal with a case such as an administrative review. We can deal with a case such as a special exception. In tonight's case, we're going to be dealing with a case that's a variance. And the variance from the terms of our zoning is it may be authorized by the Board of Appeals, and we have to have proof of evidence of the record that, and there's a couple of things I just want to go over. It's just so we can stay focused on what our role is in this variance case this evening. And so, you know, we have 7 elements here, And they were also included in your packet, but I'm just going to go over and read them just quickly so we can keep them in the front of our minds here. So number one is, by reason of exceptional narrowness, shallowness, shape, topographical conditions, or other extraordinary situations or conditions peculiar to a specific parcel of property or improvements thereon, the strict application of the terms and regulations would result in peculiar or unusual difficulties to, or exceptional or undue hardship upon the owner's use of his or her property. And then number two is, such variance is the minimum reasonably necessary to overcome the aforesaid exceptional circumstances, which I just said in number one. Number three is, such variance will not be detrimental to the use and enjoyment of the neighboring properties. Number four, such variance can be granted without substantial impairment to the improvement of the master plan affecting the subject property. Number five, such variance will not substantially impact or affect the character of the surrounding neighborhood. Number 6 of 7, the extraordinary situation or condition or the exceptional or undue hardship was not caused or created by the petitioner or any predecessor in interest. And number 7, the grant of the variance will not permit or authorize a use of the property prohibited or not permitted under the zoning code there. So for this, for the Board of Appeals for Gaithersburg. So go ahead, Frank.
What was the source of those 7 items? I'm just curious,
What
Madam
was the what?
Chair. The source of,
The source of that was from the Board of Appeals decision-making and motions.
oh, okay. Because I believe it was the 6th item in terms of you said that it couldn't be caused by the petitioner or the petitioner's predecessor in title. Actually, it's only the petitioner.
Okay.
The element of predecessor in title does appear in some elements when hardship is required, but for a variance, actually predecessor in title isn't part of it. It really has to be caused by the applicant or petitioner themselves. And just noticing that, I don't know whether your rundown included the peculiarity. I was listening to the first part of it because you were laying
Yes.
out the size and depth,
Right.
and that has to establish peculiarity. I just wanted to make sure everybody's on the same page. Don't mean to interrupt you in any way,
No,
but
please, let's get this at the beginning.
absolutely.
Yes. So noted on the predecessor statement, and then in number 1, I did reference the peculiar or unusual difficulties to the exceptional or undue hardship upon the owner's use of this property.
Okay. The reason why I mentioned peculiarity is there is a definition in the zoning definition section 24.1, and that does lay out a variance, and peculiarity is emphasized there as well, that there has to be a peculiarity, which is also what I think both the applicant and staff have emphasized, but just to keep that in mind as well.
Okay.
Because that was an issue with the variance last month as well, and since the board hasn't had the chance to do variances, this is all a learning experience, so.
Exactly. Thank
Can
you.
it's owner or tenant, correct? Undue.
Generally, it would be the applicant, so
Okay,
it depends on
in this
who's
case, it would
applying,
be the
and
tenant.
typically it would be the owner who would be applying, but it is applicant.
Okay.
Any other questions from the board to Frank? Okay, so then now moving forward, I'd like to, we can put on the record now, if any of the board members actually made a site visit to the property so that we can capture that before we get into the whole discussion here.
And yes, I did make a drive-by of your property. And, just I'd like to get a lay of the land and make sure I understand. Photos sometimes don't do things justice. And so I guess I did that on Monday.
Okay.
What day of the week would that be, Caroline?
That was Monday.
Yeah, but we have to identify the day,
Oh, the day was the 6th.
or the
November
date of the
6th.
day.
November 6th.
Okay, November 6th. So, yeah, so I did, and so there we go.
Okay. Anybody else? Okay. All right, so I think now we're ready for introduction of the case. Now, Stuart, I understand you're an attorney, so you're already an officer of the court, so I don't need to swear you in. Is there anybody else that's going to testify this evening that I should go ahead and swear in as a witness that you recommend?
Yes, ma'am. We have Chad Kellner from AstraZeneca and Steve Crum from McCree Centers in Glasscock, 2 witnesses besides me.
Okay, so I'll swear you both in at the same time. If you just want to go ahead and you can just raise your hand. And do you solemnly swear and affirm under the penalties of perjury that the testimony you're about to give in this matter shall be the truth and nothing but the truth?
Yes.
Yes. Okay, all right, thank you. Please proceed.
You done?
Yep.
All right, good evening, everyone. I'm Stuart Barr with the law firm Lurch, Early and Brewer in Bethesda. I'm a land use and zoning attorney. I've been practicing for about 22 years now. Done a lot of work in the city of Gaithersburg, mostly with the planning department, city attorney's office, mayor and council, and the planning commission. I know I've appeared with the Board of Appeals previously, though it has been some time, and if recollection serves, that may have been in connection with a conditional use or special exception. Can't recall if I've actually ever handled a variance request with the board, but thank you for the opportunity this evening to listen to this variance request and take the time with us.
Okay.
Before I start, I actually do want to pick up on the conversation that was just had, because
Please.
I'm glad that City Attorney Johnson asked the question, because, and I'm not at all concerned about the standards that you described, but when I reviewed all the City of Gaithersburg materials, that list of 7 elements was not included in the materials that I have. Can I ask you, is that an internal Board of Appeals document that you're referring to, or something that is codified somewhere?
I'd like
I'll refer
to
to
clarify
Caroline.
it. So those are things that elements of a variance that are outdated in that the zoning ordinance had been rewritten, and those are no longer in the zoning ordinance. So, but they were just things that were used by the board in the past, kind of to compare, to review. So what's in the staff report is the definition of a variance, and the which probably is the thing to be read. If you want to read that into the record, that is what you are looking to decide whether or not it meets that test. So it's really the definition in section 24(1) of the zoning ordinance. All of those 7 items, there are actually things that may reappear after the zoning ordinance is rewritten next year. But at the moment, they are not in the zoning ordinance. So
Okay, so let's back
they're
up.
just guidance.
So let's back up.
Yeah.
And
If you want, I'll be happy to read the definition. Much of what you said is there, but what I was looking for, the peculiarity, and partly that's, and then also the applicant. And the definition does clarify that fairly nicely. A variance under, and this is section 24(1) of the city ordinance, a modification only of the density, bulk, dimensional, or area requirements in the zoning law that is not contrary to the public interest, and where, owing to conditions peculiar to the property, and not because of any action taken by the applicant, a literal enforcement of the zoning law would result in unnecessary hardship or practical difficulty as specified in the zoning law.
that's a little tighter language there. I like that.
Much of what you were discussing actually is reflected there, but those are the specific standards that under the definition be operating under tonight.
Okay, all right.
Well,
Thank you, Stuart.
That's helpful. Thank you to Caroline and to City Attorney Johnson. So, right, some of the standards that you read, Madam Chair, I think are similar to county standards. I've handled variance applications in the county and the city of Rockville and other jurisdictions. So that a lot of that sounded very familiar, and I think
Okay.
we're all essentially talking about the same things, just stated kind of in different wordsmith language. But we're happy to talk about whatever standards you need to apply to.
I think we'll go with the city
Okay.
standards
All right.
this evening.
I'm not trying to disrupt your process and what you find important when considering a variance application. I'm happy to address, like I said, any standards you want to tell me to address, because this is an important matter. And but we when reviewing the staff report, did find the breakdown of basically the four elements to be consistent with our understanding of how this jurisdiction, City of Gaithersburg, analyzes a variance request. So,
Okay.
but if there are any other questions about any other standards that you would like us to address, we're always available to help do that tonight. So this is important to AstraZeneca, Alexandria Real Estate Equities, the property owner, and I would say to the City of Gaithersburg, this request. We wouldn't be here tonight with our team and asking you to take the time this evening unless this was a very important matter. So just some introductions. I mentioned that our team tonight includes Chad Kellner with AstraZeneca. He's the head of Gaithersburg site operations. We also have Steve Crum and Brian Donnelly. They are experts in planning and civil engineering with McCrease, Hendricks, and Glasscock. Brian's available to answer any questions, but Steve will actually testify after Chad. So here's how I would like to organize our presentation this evening. I would like to explain some context of this project, go through some slides that we have, and talk about why we're here, what the request is in connection with the project and the variance, and just provide some background information that I think should be helpful. Then Chad will testify on behalf of AstraZeneca about the project and the need and the urgency. Then Steve Crum from McCrease Hendricks will testify as an expert in civil engineering about the project and the variance standards. Then after their testimony, I want to circle back to the variance standards and address each one and explain how this application does in fact meet the applicable standards and why it should be approved. Of course, kind of similar to what I said a minute ago, if there's anything unclear about our presentation or anything that we need to address further, please just ask us, and we're always available throughout tonight to answer any questions. All right, so some context. And I find this context to be helpful and important to why we're here, although some of it may be relevant to the findings you need to review when deciding the variance request. Some of it may just be context and not necessarily relevant to the variance findings. But this is our property. Does everyone have access to the aerial? It has 3 buildings on it. 25, hopefully everyone can see the mouse, 25 down here, 35 kind of on the top right, and 45 West Watkins Mill Road. This property with the 3 buildings is owned by an affiliate of Alexandria Real Estate Equities. It's part of a larger development called the Bennington Corporate Center. And a portion of this building, 45, the kind of northern portion of it, is leased to AstraZeneca. And I'm sure all of you are probably familiar with AstraZeneca as a company to some degree, but long story short, AstraZeneca is a global research-based biopharmaceutical company, one of the biggest employers in the city. And if you're not familiar with AstraZeneca, then you may be with MedImmune. I've represented both MedImmune and AstraZeneca for many years, and I kind of use those names interchangeably. For tonight's purposes, I'll try to just stick with AstraZeneca, but MedImmune is a subsidiary of AstraZeneca. So AstraZeneca leases a portion of this building at 45 West Watkins Mill Road. Given the nature of the particular operations at this facility, there is very particular and specialized equipment in this building. And the technicalities of that are above me, but Chad can answer any questions about the type of equipment or the technical specs if you need it. But long story short, there's an urgent need to address some of the outdated equipment and make some much-needed infrastructure improvements. So to address those urgent needs, AstraZeneca is proposing 2 very small additions. And we refer to, they're shown on this aerial photo, we refer to the north side addition, which is the one I'm circling with the mouse, as the corridor addition or cell therapy addition, and the addition on the east side as the utility addition or waste treatment addition. Very small additions, and we're not aware that the project itself is controversial at all, at least that we're aware of. In all likelihood, probably not visible from off the property by the residential community to the west. We can't confirm that, but very small additions, and so we don't think there's really any concerns as far as the project itself. But as everyone, and these slides just provide a little bit more background information. The addition on the east side is slightly less than 1,200 square feet, and on the north side, slightly less than 1,000 square feet. This slide just shows existing building coverage on the property with the 3 buildings, and on the right here, the 3 buildings plus in orange the small additions that are proposed for the additional building coverage. And then I just took some photos to try to give everyone a sense of the lay of the land out there. This is the north side of the existing building. So this would be looking this way at the building with where the proposed corridor addition is to be located. And then these are just some photos on the east side. So this would be looking this way where the proposed utility addition will be located, also a generator. So hopefully that gives everyone just a general sense of the project. So what's the problem? Well, in the I3 zone, there's a 25% lot coverage limitation, and based on the current building coverage, the property is at that limitation. So naturally, AstraZeneca and the team studied all the options very extensively. We started with looking, first of all, at our calculations, our lot size, our building coverage to make sure that was all accurate. We looked at definitions, interpretations, how are we understanding properly all the provisions, are we making sure we understand everything correctly. Then we looked at more practical solutions. Can we locate equipment on the roof? As you can see from this photo on the north side where AstraZeneca leases space, there's a lot of equipment currently on the roof, which unfortunately is very difficult to maneuver around. So that's not a viable option, but we looked at vertical construction to limit building coverage, creating potentially open air spaces that wouldn't count towards lot coverage and so forth. We flipped this thing every which way, right? Looking at all options, could we remove some outbuildings? Unfortunately, that didn't capture quite enough square footage, but needless to say, we turned it every which way. I will address the planning staff's preferred approach that was discussed in the staff report involving re-subdivision later, because I do want to discuss that, because we did look at that. But right now, as everyone's aware, we're proposing a variance because we strongly believe we meet the variance standards. Now, just to make sure all of us understand the scope of the request, based on the size of the proposed additions, we are asking the board to approve a lot coverage variance for this property from 25% to 25.67%. In other words, we are asking for a 2/3 of 1% increase above the 25% limitation. That is the scope. Now, I'd like to point out that, as it turns out, somewhat coincidentally, I think, the city is undergoing a kind of once-in-a-generation rewrite of the city's zoning ordinance. I think probably the board's familiar with that effort. It's called Retool Gaithersburg. It started earlier this year. It's scheduled to continue into next year, and the city's looking comprehensively at all the zoning ordinance provisions, and there's a consultant that's helping to make recommendations, and one thing that is being reviewed is lot coverage in the I3 zone. And in fact, my understanding is that the consultant for Retool Gaithersburg is recommending an increase in lot coverage in the I3 zone from the existing 25% to 75%. And staff can correct me if I'm wrong, but I believe the planning department is supportive of that request. But again, they can correct me if I'm wrong on that. But in any event, that appears to be the recommendation. So completely, dramatically changing lot coverage in the I3 zone, tripling it, which long-term will really address some potential challenges that property owners face in the I3 zone. Now, of course, none of us have a perfect crystal ball, so I'm not suggesting in any way that that is a guaranteed outcome. We all know how things can change, so there's no necessarily resulting increase in the lot coverage in the I3 zone. We're not suggesting that there is. However, what I am suggesting is that if that does result next year with Retool Gaithersburg, by the way, unfortunately, we can't wait for Retool Gaithersburg, unfortunately, just given the urgency. We would love to just let that unfold, hopefully have that address the problem and be on our way, but the project's more urgent than that. So, but if Retool Gaithersburg does legislatively address that challenge, then there's a real possibility that if a variance is granted this evening, that we are basically accommodating a very limited short-term interim solution. And if a variance is granted and then Retool comes along and significantly increases the lot coverage, then the variance would be deemed kind of obsolete at that point. And so that is essentially what we're asking for. We're asking for immediate interim relief that is necessary here. And so I hope that provides some of the context of why we're here. Let me just show you a couple more slides that are going to be relevant to our discussion of the variance standards and the request. This is just a quick exhibit that shows our property in orange, parcel E, shows the 3 buildings, and then the adjoining property in blue, parcel F. We'll talk about those 2 properties. It also shows the Bennington Corporate Center as a whole. So you can kind of see when we refer to the Bennington Corporate Center what we're talking about. We're talking about kind of an overall development there. And this photo just simply, this photo is taken as if you were standing here at the pipe stem on Clopper Road and looking down this pipe stem of parcel F. What it shows is that it's basically wooded, it's unimproved, and as we'll discuss the significance of that later, but there's not a connection, a physical connection through the pipe stem. That's this property, what this property shows. This also is just an excerpt from the kind of governing documents of the corporate center, which is relevant because it shows, as it's cross-hatched here, the pipe stem is considered kind of common area. So it does not provide access to parcel F. And I'll explain the significance of that later. And then this just shows a highlighted portion of the pipe stem, which adjoins our property, parcel E. So, as we discussed, and I just want to clarify, the variance standards applicable this evening, Maryland case law kind of has a 2-part test. I think the city of Gaithersburg really it's more accurate to say there are kind of 4 elements. That conditions are peculiar to the property, that those conditions are not due to any action by the applicant, or stated slightly differently, that there's been no self-created hardship, that there's practical difficulty, and that the variance approval would not be contrary to the public interest. Those are the standards. And the other thing I'll just add is that what case law says is that there needs to be a connection between the peculiar conditions and the practical difficulty and the request for the variance, right? It makes sense that there's a nexus between those items. You can't just argue there are some peculiar conditions and argue some practical difficulty, but if they're not related, you're not making a successful variance argument. So with that as background, unless there are any questions about what I just said, the background, then we'll have Chad and Steve testify, and then I want to come back and obviously address the arguments. Are there any questions?
I say that we hear all from you, and then we'll come
Perfect.
back to the questions that serves the board.
Sounds great.
Coordinate.
Okay, Chad, do you want to?
Sure. So thanks, Stuart. Thanks for having me here tonight to discuss the variance. I appreciate the time and the opportunity. So as I was introduced, I'm Chad Kellner. I'm the head of site operations for Gaithersburg's AstraZeneca site. I also represent San Francisco and New York, not that that's applicable for here, which is good. So I've been with AstraZeneca/MedImmune for 22 years. I actually started at 25 West Watkins Mill before we since turned that back over. And we've appreciated the relationship that we've had with the city. We launched our first product out of 35 West Watkins Mill in 80, I believe it was 89, to start. Since we've grown to over 5,000 employees and contractors on across our 1.5 million roughly square feet in Gaithersburg. With that said, our pipeline is growing, our drug pipeline is growing at an extraordinary pace. There for a while, early on shortly after AstraZeneca acquired MedImmune, AstraZeneca's pipeline was struggling. We have since turned that around, primarily due to the efforts that have happened at the Gaithersburg campus. We're now one of the top 10 pharmaceutical companies in the world. With that said, the research that we do here covers 3 primary therapeutic areas, including oncology, respiratory, and infectious disease. And the cancer, primarily the research that's done here in Gaithersburg is focused on cancer and oncology. And the cancer field itself and the oncology field has transformed dramatically over the last 10 years. And specifically, we're targeting new therapeutic models and new modalities for drugs that we can give to patients to extend and hopefully cure cancer in the near future. Building 45, as we refer to it, 45 West Watkins Mill, is critical. I can't overstate the criticality of 45, that little tiny parcel of building, because that is the leading edge of cancer research for AstraZeneca. It's also the tip of the spear, if you will, across the entire oncology space for how new cancer therapies will be developed, and that activity happens exclusively at Building 45. Our drug pipeline is growing at a pace, I mentioned this previously, at a pace that's unparalleled across our pharmaceutical peers, and in order for us to keep that pace and continue delivering the medicines to our patients, the variance will allow us to build onto the space to give us the compliance space that we need for continuing the research in a clean GMP pharmaceutical way. On the flip side of that, I think Mr. Young visited the building earlier in the week, and I'm not sure if the trailer was still in the back of the building that was providing support utility for the infrastructure that is currently failing over at 45 West Watkins Mill. So we have had some critical failures which have had a significant impact to our pipeline and our delivery. So we have been battling that while we've been, as Stuart indicated, as we've been reworking and redesigning different options to see if there was a way not to come to the board with a variance application. So Stuart did reference going vertical. He's also referenced changing to interior rooms, maybe slowing down the pipeline. None of that really suits the patients. And what we're after is how do we bring medicines to patients faster so that we can save lives. So again, I cannot overstate the criticality and what that variance and what Building 45 specifically does for AstraZeneca and ultimately the patients that we serve. So we've had a very, very long-standing relationship with the city, and as our pipeline continues to progress, I don't want to get to a point where we have to make different decisions about where our drugs are manufactured or where they're researched, just based on a small addition to what is a critical utility infrastructure for us on campus.
Hey, I do have just one quick question. Sure. And I understand a wastewater treatment building, but what is the other addition going to be used for, in layman's terms?
In layman's terms, so the wastewater treatment was the square box at the bottom of the one
that
slide.
one I understand.
The one at the top on Plan North of that is a corridor. It's a clean access corridor to get from a patient area where we would dose a clinical trial for a patient, and we can safely egress out of that room and ingress to a different part of the building.
So that's where you would do that. It's a secure.
It's just a secure
sterile-
walkway. That's all
And then
it
they
is.
go.
Yes,
Okay, so that's going to be used for actually patients are going to be in there.
that's correct.
Okay, thank you. That's it.
Okay. Thanks, thank you.
I'm good.
Any other questions for Chad? Okay. Steve? Which side do you want?
I don't care. This works fine. For the record, I'm Steve Crum with McCrease Hendricks and Glasscock. We're the civil engineers representing the applicant. So I'm going to talk about the compliance with the
Sorry. I would like Mr. Crum acknowledged or admitted as an expert in civil engineering.
Okay, so noted for the
Thank you.
record.
Thank you. So I'm going to talk about compliance with the variance standards and why we believe that what we're asking for complies with all the standards in the zoning ordinance. So first, I want to talk about the peculiarity of the subject property. I would note that one definition of peculiar is different from the usual or normal. And with the exhibit that we have here, there are several notable conditions that I want to point out. And while area, shape, and topography are often thought of as peculiar conditions, in this particular case, I think an important peculiarity is that the vehicular access to this corporate park is served through the subject parcel. And I don't know if I can grab this, but oops, that's not good. So typically, you would find the access is exclusive to the parcel in question. So, but in this particular case, both parcel E and parcel H provide all the vehicular access to the entire park. Parcel J doesn't have access to a public street, parcel D doesn't have access to a public street, and parcel F doesn't have access to a public street. All of the access is from this loop road and is completely contained within parcel H, and the majority of it's actually contained within parcel E. And I think that's a peculiar, not normal condition that makes this property different than other properties. So, and then a second point is that we're adjacent to this pipe stem that it serves the legal frontage for parcel F. And how do I go to the next? Keep going all the way to the end.
This one?
Yep. So this is an exhibit from the city of Gaithersburg's zoning ordinance, and these are lot types. And
Can I interrupt for 1 second? I just want to add an exhibit number to it for the record, since this was not in their package. So this will be exhibit number 18.
So these are the zoning ordinance talks about different types of lots: corner lots, through lots, interior lots. Doesn't show a pipe stem lot, although we know that those exist in the city. But typically, normally, a lot has frontage on a public street, and then it adjoins either a side or a rear yard of the adjoining property. It doesn't adjoin a pipe stem. as is the case in this particular application. So I think those two things provide evidence that this is a particular property. This is not a normal conventional lot. So the next item is not due to action of the applicant. To the best of my knowledge, AstraZeneca didn't create the subdivision that made Lot E the size that it is, nor did the current owner. The subdivision was done prior to Alexandria acquiring the property. So I think, we meet that standard as well. Moving on to the unnecessary hardship and practical difficulty, I think you heard Mr. Barr speak about that the applicant, AstraZeneca, their design team, looked at every available option that the architects, the structural engineers, and the civil engineers could think of to find a way to make the improvements that we need to make to this critical infrastructure and not have to come before this board and ask for a variance. The aerial photograph shows all the equipment that's on the roof. The nature of the equipment that goes into the wastewater facility needs to be on the ground level. There's actually a mezzanine, so there's some of the equipment is elevated a little bit, but it needs to be at it needs to be on the ground. And obviously the corridor addition, we're going to have patients visiting this building during clinical trials, and they need to be able to come in from the ground floor, not some other location. So to ask the applicant to, move all the equipment on the roof, create space for more equipment that may or may not fit or may not be structurally, the roof may not even be structurally strong enough to support it, would be, an unnecessary hardship and a practical difficulty. And then I think finally, not contrary to the public interest. The additions that we're asking for are the minimum that we need to accommodate the equipment and the criteria for the patients in the corridor addition. This is not a major atrium, grandiose entrance to the building. This is very modest. We're not asking for more than we need. The architects have been very careful about accommodating the equipment and not having, surplus space that is unnecessary. I think that when you look at the just the aerial.
This?
Yeah.
Or this?
That one's fine. This property functions because of this shared access road that goes through two of the parcels and only two of the parcels, functions much more like a single lot with multiple buildings than multiple buildings on multiple lots. And I think if you look at this holistically, the building coverage is only 22% across the entire project. So by granting this variance, although it only is going to apply to parcel E, we're not increasing the coverage to the point where the public would notice. I don't think there's any worry that this is somehow going to result in more variances being filed to try to avoid complying with the zoning ordinance. So when you think of this property in a holistic manner, I think there's not a problem with granting the variance. I think we meet all the tests, it's very modest, less than 1% increase. So if there are any questions, I'd be happy to try to answer those.
Okay.
And then I want to follow up.
Okay, why don't you follow up, and
Okay.
then we'll do the,
We just wanted to pause in case there are any particular questions for Mr. Crum, otherwise we'll keep going.
please proceed.
Okay.
Okay.
So I want to supplement the testimony from Mr. Kellner and Mr. Crum, and I might ask Mr. Crum some questions just to follow up. But so let's go through the standards for granting a variance in the city of Gaithersburg. And needless to say, we respectfully disagree with the staff report. We think it does meet the standards. We strongly believe that. So again, conditions peculiar to the property, not due to the action by the applicant, no self-created hardship, practical difficulty, and not contrary to the public interest. And again, there needs to be a connection, and there is here, as we'll explain, between the peculiar conditions, the practical difficulty, and the request for the variance. There's a nexus there. All right, conditions peculiar. Why is the subject property, parcel E, sized the way that it is? And why does it have peculiar conditions? Parcel E, our property, subject property, has peculiar conditions for the following reasons, some of which Mr. Crum explained, but let me enhance. The property does not extend to the western boundary of the Bennington Corporate Center. It does not extend to the outer boundary of the overall corporate development. Why doesn't it extend? Because of the existence of this intervening unimproved pipe stem lot for parcel F. Why is there that pipe stem lot for parcel F? Because of the city's frontage requirement. We do agree with the planning staff's conclusion, because it makes logical sense, that properties generally have to connect to a public road, had to have some connection to public frontage. So that makes perfect sense that is why the pipe stem was created. We agree with the staff on that point. And that's to enable access, obviously, and to avoid landlocked properties, right? Except here, the pipe stem does not provide access to parcel F for the reasons Mr. Crum explained. It's unimproved, and that's reflected in this photograph, and I don't think there's any disagreement that it is unimproved, the pipe stem. So, in fact, as Mr. Crum explained, parcel E, our property, the subject property, provides access, along with parcel H, to the rest of the properties. And not only does through this kind of ring road, but not only does the pipe stem not provide access to parcel F, it in fact is considered common area under the Bennington Corporate Center governing documents. And that's just this excerpt, right? Which shows in cross-hatched here this pipe stem that's considered common area. So those are the peculiar conditions. We are not saying that the existence of a pipe stem property in and of itself alone creates peculiar conditions. We are saying that when you combine all of those factors that I just described, you get peculiar conditions. To kind of state it another way, members of the board, if this is the universe of City of Gaithersburg properties, and you were to limit it down to pipe stem properties or properties adjoining pipe stem properties, you'd have a smaller subset of that group. Within that group, there is a smaller subset of properties that do not actually have physical access through that pipe stem to the property. And within that group, you have an even smaller subset of properties that are considered common area in an overall corporate center, such as this one, right? So when you narrow it down, you are left with conditions that could very well be one of a kind in the city of Gaithersburg. Now, we can't prove the negative, that there's no other conditions like it in the city. We just don't have the time and wherewithal to go through that exercise. However, if I asked Mr. Crum, are you aware of any other conditions that meet all of those similarities in the city, you would say?
I'm not aware of another situation.
Okay. So the staff report references 2 other pipe stems that are nearby. So let's just discuss those because we believe that there are distinguishing characteristics. Those 2 pipe stems are shown here on the aerial. This one right next to us to the north, again, that's parcel H, I believe.
Yes.
That pipe stem provides direct access to parcel H, okay? A distinguishing characteristic from the pipe stem for parcel F. Similarly, this pipe stem over on the other side of West Watkins Mill Road, there's a portion of it you can see, is improved, looks like with a parking lot. So that's a distinguishing characteristic from, again, the pipe stem in question, which is unimproved. So there are differences between the 2 pipe stems identified in the staff report and the circumstances we have in connection with our property, which again are very peculiar conditions. I would use the word very. So if there are other circumstances in the city that share all these characteristics, we're simply not aware of those. Now, I will add, to follow up to what Mr. Crum said, that because of the lot configurations in this overall Bennington Corporate Center, and because of an existing stormwater management facility in this kind of northwest corner, parcel F, the pipe stem property, has less building coverage than it could, under the maximum limits. It has about half of the maximum, about 12.5%, when the limit is 25%. Consequently, the overall lot coverage within Bennington Corporate Center, when you total all the properties together, is less than 25% total coverage. I think it's more like 22%. We would assert that those are peculiar conditions, but in fairness, I think that we would make that argument more in connection with the public interest, which is, as Mr. Crum said, we're not proposing, when you look at the overall Bennington Corporate Center, to increase coverage in total beyond 25%. So but those, I believe, are peculiar conditions nonetheless. So let's move to the next standard, action not due to action by the applicant, or stated differently, that there's been no self-created hardship. I think we actually agree with the planning staff on this element, because I think they basically recognize that there is no self-created hardship. But as was stated, neither AstraZeneca nor Alexandria Real Estate Equities, the property owner, were involved in the original subdivision. I will note, though, just as an aside, that even if they were involved in the original subdivision, or even if they were considered together with predecessors in title as one kind of combined applicant, the Maryland case law says that when the government statute permits and encourages an owner to take certain action in order to be able to utilize property, for example, a subdivision process, that action does not amount to self-created hardship. And that makes sense, right? Because if the government could always say, we're going to consider you, the current applicant, to be combined with your predecessors in title and all one applicant, and you all created the subdivision to begin with, the government could always deny a variance application, because the applicant is always creating the lot lines, is always creating the original subdivision, right? So in any event, though, these particular parties were not involved, and so there is no self-created hardship in this case. Let's talk about practical difficulty. You heard, I think, the AstraZeneca kind of presentation of the need for the project, the urgency. Practical difficulty in the variance context is somewhat more nuanced, so let's discuss that. So, and we agree with the staff report that notes that the lesser standard of practical difficulty versus unnecessary hardship is the one that applies, practical difficulty. So practical difficulty exists here because of the inability to maximize lot coverage within this particular property, as it should be configured logically for lot coverage purposes, and the inability to add any additional lot coverage given the current coverage amounts, and more specifically in this particular situation, the inability to make very modest and needed improvements to aging infrastructure within the existing building. Why does that practical difficulty exist? It exists because of the limited amount of lot coverage that's available. Why is there limited lot coverage? Because of the size of the property. And the size of the property relates back to the peculiar conditions that we just discussed. In other words, it's all connected. There's practical difficulty because of the size of the property, and the size of the property is impacted by the conditions peculiar. That's the general thrust of why there's practical difficulty in peculiar conditions and why there's justification for variance relief. Now, to a lesser extent, we also think there's practical difficulty in the inability of the overall corporate center to maximize lot coverage within the overall development. But again, I think that's more related to the public interest argument, which I'll get to in a second. But I just want to respond to some of the comments in the staff report when it comes to practical difficulty, because we just respectfully disagree on this point. So the reasons explained for the staff not supporting a finding of practical difficulty is that the property without the variance is being used for its permitted purpose without unnecessary burden. Well, I think tenants like AstraZeneca and property owners like Alexandria Real Estate Equities are looking for more than just the ability to use the property for its permitted purpose, okay? Tenants and property owners are really looking for not only the ability to use the property for its permitted purpose, but under extenuating circumstances or special circumstances, to be able to accommodate within that building a need to update infrastructure, a need to address failing infrastructure is the term used, and the ability basically not only to use the property for its permitted purpose, but to reasonably able to use that property going forward and to address problems such as exist here. So I think my kind of friendly suggestion is that we need to look at a standard that is more than just have we allowed the property owner to use the property for its permitted purpose. I think we can, especially when it comes to the types of businesses and property owners and tenants that we're trying to attract in the city, we want to give them the ability to address failing infrastructure, make necessary upgrades within reason, right? To be able to continue to use those properties for its permitted purpose going forward. And the fact is, members of the board, we have highly specialized life sciences companies that are doing amazing things, but they have special needs, right? And we want to, and I would say that if we are taking the position that, well, we've given you the property and allowed you to use it for its permitted purpose, but if you want to go beyond the very specific lot coverage limit we have, you can't do that, and that does not place an unnecessary burden. I would argue that does place an unnecessary burden. I do want to address the suggestion that we take a different approach to addressing this problem. I want to do that in just a moment, but as far as practical difficulty, I don't think there's any question it exists here. Not contrary to the public interest, again, we strongly disagree with the staff report on this. This variance would allow very small, necessary, and urgent building additions. It would allow the lot coverage across the entire Bennington Corporate Center not to exceed 25%. The project is not controversial that we're aware of. These proposed additions do not detrimentally impact any other properties. The variance relief, if granted, will not in any way adversely impact any other property owners. So again, as I mentioned, Retool Gaithersburg very well may address lot coverage problems like this in the long term, and so this variance could provide interim relief only and might become obsolete after the adoption of Retool. We don't know that for certain, but there's a very strong chance of that. And this is not going to set a precedent that should in any way, shape, or form be of concern to anybody. Look, every variance case is unique. By definition, you have to prove peculiar conditions or unique circumstances or exceptional, there are variations on the word. So by definition, variance relief is targeted at a very specific set of circumstances. And we're not aware of anyone else who can possibly come to the City of Gaithersburg Board of Appeals and said, well, you gave a variance to AstraZeneca there and we deserve it over here. We're just not aware of that. Let me address the comment in the staff report that this would somehow, an approval would somehow not be in the spirit of the zoning ordinance. Again, we disagree. What is the purpose of a lot coverage limitation in a zoning ordinance? It is, along with other development standards, such as height and setbacks, intended to limit bulk and density on a property. These are one-story buildings on this property, 25, 35, and 45. The allowable height in the I-3 zone is 110 feet. We are doing a phenomenal job of limiting bulk and density on this property. I don't mean to be flippant. There's no concern of adding a variance approval for 3,000 some odd square feet that we're in any way going to be concerned with bulk and density. That is the spirit of the zoning ordinance when it comes to lot coverage. All right, let me get to the point about the preferred approach, because this is important, because I suspect that members of the board are thinking, what are the options here? So the planning staff's preferred approach involves re-subdividing and replatting this property along with the adjoining property, which does happen to be owned by another affiliate of Alexandria Real Estate Equities. We've looked at that, and as we said, we've studied every single conceivable option. Simply stated, that approach is far more complicated, involves far more time, will take longer in terms of not only the duration of time, but the timing of the approvals, and involves more cost. Now, I'm not trying to suggest that these clients can afford that cost, but we don't want to unnecessarily spend their money either. But that's a secondary concern. I mean, we are here tonight with the board on behalf of AstraZeneca with the request to solve the lot coverage problem tonight and move this project forward based on the urgency. If the variance is denied, or we are just told simply to take the approach that the planning department would prefer and ask to re-subdivide and replat, then we're moving from addressing the problem in connection with one property to trying to address it in connection with two properties. That then involves working with Alexandria Real Estate Equities on their ownership of two distinct properties. It also involves potentially working with the lenders of those properties. It also involves working with the tenants of those buildings, because we can't just simply tell those tenants that have leases that, well, you used to be leasing this property and now you're leasing a different property. It involves figuring out complexities with respect to the Bennington Corporate Center documents, involving property boundaries and easements, access and parking, and the like, and on and on. These are real complexities, okay? I can appreciate the planning staff's preference that that approach is different from a variance and is potentially one approach, but they don't have to deal with those complexities. We do. And I'm just being candid that will significantly postpone the ability to get this project up and running. Again, and the final point on that is, if we get through that process to begin with and then re-subdivide, replat the properties, and then if Retool Gaithersburg comes along and solves the long-term lot coverage problem in the I-3 zone, Alexandria Real Estate is just going to want to reverse things back. And so we're going through the process again to re-subdivide and replat the properties to the way they are currently. Do we really need that amount of process? I sincerely hope not. But all this depends on the variance standards, right? We are not in any way suggesting that we've been backed into a corner and had to come up with a variance argument because either that was the most efficient approach for us or our preferred approach, or we had no other options. This does meet the variance standards. That's the whole crux of this application. The fact that there may be an alternative approach cuts both ways, right? We are not suggesting that the variance is far more efficient and preferred for us, thus we should be entitled to it. We're not suggesting that. We are arguing, as we've explained tonight, that it meets the variance standards. At the same time, it would be completely improper for the city to say, you do have an alternative approach, and thus we are denying the variance. That's not a basis for a denial. It all comes down to the standards and whether or not this application meets the standards or not. Look, on the final point, I love working with the planning department. It's been a phenomenal working relationship, but I take exception to one of the statements at the end that says, by ignoring the requirements necessary to grant a variance, public confidence in and reliance on the city's zoning requirements would be eroded, as the precedent set by such an approval would only compromise the Board of Appeals' ability to grant variances to those properties meeting the definition. I can't say strongly enough how much I disagree with that on multiple levels. Nobody is ignoring the requirements for granting a variance. We're here tonight making the arguments with expert testimony in our application materials in our presentation tonight. I know you won't ignore the requirements for necessary to grant a variance, because there's no scenario in which the board will somehow determine that the requirements for granting a variance are not met, but the board approves the variance anyway. That's not a possible scenario. You're not allowed to do that. So there's no possibility that we're running into that problem. The only precedent that's going to be set if you find that the variance standards are met is that applicants do have the right under state law and the City of Gaithersburg Code to ask the Board of Appeals for variance relief, and if the Board of Appeals finds that an application meets variance standards, it will grant a variance. That's the only standard precedent that we're concerned about. I see no conceivable scenario in which confidence in and reliance on the city's zoning requirements would be eroded. If the board approves a variance, look at the confluence of special circumstances here. Unique and special circumstances. One of the largest landowners in the city has a tenant that happens to be one of the largest employers in the city. Very small but very important additions are necessary for upgrading equipment and addressing aging infrastructure. As an aside, the city zoning ordinance is being reviewed to address the lot coverage problem long term, but there is an immediate problem that needs to be addressed. Peculiar conditions exist, as we explained. Practical difficulties exist, as we explained. If the board approves this variance, no reasonable person would conclude that it is somehow open season on variances in the City of Gaithersburg. That is just not possible. No reasonable person would conclude that the city is somehow ignoring variance standards or setting the bar too low, or that it will approve any variance that comes along. That is just not a possible outcome of tonight. I've said enough. In summary, this application does meet the standards for granting variance relief. This project is not controversial, but it is very important. There's no opposition that we're aware of other than the staff recommendation. The variance should be approved. Thank you very much.
Thank you for your testimony and also to the others that testified. At this time, if there's no further testimony, I'm going to now open up to the board for questions to the applicant.
Just go around the horn here.
Yeah, usually, well, I'll start with Aaron,
Sure.
and then
Madam
I'll
Chair,
recognize you, Gary.
if I would suggest,
Yeah.
just for the record, because
Yeah.
this is supposed to be part of the meeting, if there was anybody in the audience, we are sitting here now, nobody else in the audience,
Okay.
but for the record to say that anybody would have that opportunity and then they don't. So if we do want to make sure to touch on that, again, just for the record.
Thank you, Frank. Okay, so before we get to your questions, Aaron, I just want to state for the record, if there's anyone in the audience that would like to present additional testimony this evening, please step forward. Okay, nobody's here. All right. Thank you. Thank you, Frank. Okay, moving forward now. Aaron, and then I'll
No, that's
bring
fine.
Gary.
Yeah, and I feel like I have a few questions, and we may want to come back to me later,
Okay,
just based
come
on
back, sure.
how some things go.
Sure.
But thank you, it's sort of at the end for kind of honing in on the very practical question here, which is the standards themselves, because we've seen a lot of argument and heard a lot of argument around, reasoning and rationale and benefit to the public and whatnot. But when we get to the standard, what I'm wrestling with, and I would love to hear your response to this, is the standard is the elements are connected in the standard. They're not, check this box, check this box, check this box, check this box. And I think you mentioned this at the beginning when you talk about sort of a nexus between the peculiarity and the practical difficulty in particular. So I've heard a lot about the peculiarity, heard a lot about practical difficulty. In my mind, the way I read the standard, the peculiarity needs to cause the practical difficulty.
Mhm.
And I maybe I didn't process that, but I don't see where you're suggesting that the peculiarity itself is causing the practical difficulty. Can you share more on that?
Absolutely. I'm not trying to suck up. It's a very keen question. Because in all seriousness, that's
Yep.
the reason why I emphasize that there has to be a nexus, right?
Yep.
They're not separate, as you said, kind of check the box items, and once you've checked one box, or you go to the other and you check that, they're connected, right? There has to be a nexus. Let me try to explain it this way, because I wasn't successful at explaining it. I wasn't as persuasive as I needed to be.
At least to me.
but thanks for giving me the another opportunity at it. Okay. The practical difficulty, you can either look. The case law says that the Maryland case law on variances says you approach it by first looking at peculiar conditions. Are there any, are there conditions on the property that affect this property and are not affecting other properties? And then only if there are peculiar conditions do you then go to the next question of, is there practical difficulty, and how does that relate to the peculiar conditions? If you found to begin with that there were peculiar conditions. If you don't find that there are peculiar conditions, then you don't even go further.
Yep.
The other, and I can argue it that way, but the other way I think I tried to argue it in the presentation was the reverse, which is that the practical difficulty is that there's the inability to maximize lot coverage. Okay? With this particular property, as it should be configured logically for lot coverage purposes. Now, maybe what do I mean by that? Okay. We all understand that the current lot size and configuration is a certain number, and from that you calculate 25%, and that's your lot coverage. And that is the maximum allowed, and the current buildings are at the maximum. What we're saying is that given the peculiar conditions of the pipe stem, and not just a pipe stem that doesn't provide access, that is considered common area, that is essentially a landscape buffer, right? It's a row of trees that kind of separates out the or kind of screens the residential property to the west from the corporate center. Because of those peculiar conditions, this property has a limited amount of size, a different size, less size, and thus consequently less ability for lot coverage. That is essentially the connection there. Okay? Now, stated somewhat differently, so again, the test that the Maryland case law says is, are there peculiar conditions? Again, we're not aware of any other conditions that are identical. Let me be clear what I'm saying. We're not saying there are not other pipe stems. There are. We're not saying that there aren't other properties that are considered common areas. Of course there are. We're not saying, in other words, you can't take each individual point and say, well, there are examples over there, and when you take that, it's the combination. Okay, it's the overlay of all those conditions that creates a totality of peculiar conditions, right? So if you conclude there are peculiar conditions, and then you go to practical difficulty, which is, again, that this property cannot maximize lot coverage given those peculiar conditions, and is essentially limited to what it has currently, then that is the nexus, that is the connection. And I think I had the other point I just want to make is that this is less legal, more lay person, but anyone who goes out to parcel E and looks at the property and looks to the west where the pipe stem is. If you didn't know there was a pipe stem there, you would think that parcel E goes all the way to the outer limits of Bennington Corporate Center. There's just no reason to think that there's some other intervening property there. There's no building, there's no improvement. It's a patch of grass and trees that serves an important purpose. I'm not suggesting otherwise. But you would not think that there's that pipe stem there, okay? That's peculiar, right? And it drives the size of the property. And the size of the property directly dictates lot coverage, right? It's all related, right?
But then is it accurate to say then that the argument of what's peculiar to the property are things that actually aren't on the property?
Well, they're connected,
They're
okay?
connected, right, they abut,
Because, right,
yeah.
because you can't, from our standpoint, you can't really look at parcel E without looking at parcel F.
Right.
It's because number one, it's all part of the overall corporate center development. Number two, they're just so interconnected and create peculiar conditions, we would argue, that you can't really just say, well, we're not going to look beyond the property boundary of parcel E.
Right.
That's not, when you're looking at conditions peculiar, parcel F is available to be factored into peculiar conditions.
Is there precedent for that? Either what you just said or something similar, which I think is implied elsewhere, which is parcel F, which is the pipe stem. Right? Parcel F is common area, and therefore it's the functional equivalent of a larger property. Is there any precedent for thinking about it that way as an exception to the four corners, figuratively, of the subject property?
Well, I certainly can't come up with a Maryland case and offer that as precedent off the top of my head. I would love to.
Right.
But no, I'm not able to do that. But look, I do not believe that Maryland case law, when it comes to analyzing conditions peculiar, would say under these circumstances, you have to look within the boundaries of parcel E and that's it. Okay? There's just a larger context here. Why is parcel E the way it is? Well, because parcel F's the way it is. I mean, there's just such an interconnectivity there that does not exist elsewhere, again, for the reasons that we've explained. So I think there was one other way I was going to try to approach it, but I hope that does the trick.
Yeah, well, I've got a couple other questions I think are somewhat related as well. So the current development on the parcel, F, right?
Our property is parcel E.
E, excuse me. I don't know why I keep mixing these up. It's basically to the limit of lot coverage. It's at 25%. So the development, when it happened, applicant or otherwise, like that was contemplated and measured, I assume, that it's not a coincidence that it's pushing up against that limit. Okay, so there was an understanding from the get-go that parcel E sort of stood for itself and not with reference to parcel F behind it, it would seem. Is that accurate?
So I can't tell you that I am familiar with the entirety of the history of the Bennington Corporate Center. I think it would make sense to say, well, I think what we do know is that the three buildings were built before it was then subdivided.
Originally, there were two parcels, parcel A and parcel B. Parcel A is the building across on the east side of West Watkins Mill.
This is the original.
And then parcel B was the whole on the west side of West Watkins Mill Road. And the three buildings were built under parcel B before it was subdivided. So there wasn't a understanding that, hey, we're limiting ourselves to 25% coverage by creating these lot lines.
So it's just coincidence?
Well, as time went forward, different entities wanted to actually own their building and the land that it was on, and that's what created the subdivision. That why you know, I don't want to lease a portion of this big parcel. I want to know that I've got my building and I've got my land.
Sure. I'm just trying to understand sort of remarkable coincidence or otherwise.
Yes.
Of that 25% limit sort of hitting it. And then, so we talked a little bit about sort of the consideration of parcel F as, you know, theoretically common ground. Is there a way to kind of consider it that way? You mentioned in your testimony, when you look at the Bennington corporate area holistically, right, and we get to this 22% number, are we aware of doing something along those lines? If not, sort of the functional equivalent of a common area, of taking a broader development and reapplying the same standard? Or is that more of a policy
We
argument?
talked about the possibility of looking at the entire corporate center as one overall property under which you can't exceed 25% total within that boundary, but that just wasn't available. I think the planning department would say they don't have the authority to do that, or that's not consistent with what the current standard for lot coverage
Okay, so
says
it's more of like
you
a
have to do. Yeah,
policy
it's not,
argument, yeah.
it's not an available technique. We would love, that was one of the first things that came up, though,
Yeah.
of course,
Yeah.
is
Could we
can
average?
we essentially look at this as one development? But again, I think it goes towards public interest,
Sure.
right? I mean, we're not blowing through 25% across the entire development.
Yeah.
I mean, that might be a different story if we were proposing that, but we're not.
Yeah, okay. I'd love to ask two more questions, one of which is sort of your response to a hypothetical, and then the other is a totally different question. So on the response to the hypothetical, so you'd said something near the end of, you know, we're not setting a precedent that other property owners, other applicants are going to meet the limit of the coverage and then later apply for more coverage and say, well, AstraZeneca got it, right? I mean, is that necessarily true? So think of and this is a hypothetical, right? It's like we're back in law school, but like bad actor that says, I got 25% I can cover. I'm going to build to the 25%, and I just know that at some point the capacity, the capability of this building is going to fail, right? Because I don't have the proper HVAC, I don't have the proper, you know, whatever it might be. But that's okay. Gaithersburg is going to, you know, when I come back and say I need that much more because my infrastructure failed, they're going to give me that extra space. So, what is that the kind of precedent that we're potentially setting here?
I don't think so. First of all, I can't obviously say to you, no one else is going to apply for.
Sure.
You're going to get variance applications.
Yep.
That's just the nature of the fact that variance relief is available, again, under state law and city code. And when applicants believe they meet the standards, which are rigorous and I think understandably so. Look, we're not in any way suggesting that anytime there's a problem, applicants should run towards a variance application. What case law says is that it should be used sparingly. I think that's a fair word. It's a rigorous test. We've been through all the elements tonight, but as you can imagine, it's a high bar to reach. We firmly believe we meet that bar. Look, can someone somewhere in the city possibly compare this set of circumstances to their set of circumstances? I can't tell you that's impossible, but that's a basis for denial. Because somebody else might come along and say, you know, I saw you gave variance relief to AstraZeneca. I'm curious. I'm interested in that. That should not be a concern here. I firmly believe that. And if you, in any way, the board receives some kind of uptick in the number of variance applications, I'll be shocked.
Understood. Okay, so my last question is unrelated to this line of questioning. We heard testimony tonight about the vehicular access, right? That was how you started your testimony. And maybe I'd missed that nexus. How is the vehicular access description that we're talking about, how is that related to everything we're talking about today with respect to the variance and lot coverage?
Because typically, normally, a piece of property, a lot or a parcel, has an exclusive access to a public street. I mean, the subdivision ordinance requires that every parcel have frontage on a public street. So, and under normal circumstances, that frontage is used as the vehicular access to the parcel, as parcel H is a perfect example of that, is that it's a pipe stem, it has its frontage on West Watkins Mill Road, it has its access, its vehicular access, gets to the building. It happens to be shared with other parcels within the corporate park, but that's the normal. And the fact that the other parcel F doesn't have vehicular access in its panhandle makes it different, not normal. Other two parcels that front on the one on the corner of Clopper and West Watkins doesn't have any access to a public street. Has frontage, but no vehicular access. So, that adds to the peculiarity of parcel E.
Okay, so
Stated-
it's part of the peculiarity description, has nothing to do with the calculation of lot coverage
Nope.
or
No,
any
peculiar
other practical
conditions.
difficulty or, okay.
Because I think just to follow up on that, I think what we're saying is, without in any way conceding anything, if parcel F derived access through the pipe stem, might be a different set of circumstances, okay? But it doesn't. It derives access, as explained, through the ring road, which is on parcel E and parcel H. I think it just those would be slightly different conditions that I would still argue are peculiar, of course. But are they really? It's maybe we have a stronger argument because of the fact that there's not access through the pipe stem. That's the point.
Got it. Okay. Thank you.
Okay, thank you, Eric. Gary?
So I try to respect both sides here when I think about this. I think the city has obviously put a lot of time into their decision as to why they think this is something that should move forward. But I also believe that you guys wouldn't be here tonight spending your time to lay out your reasons why. And so a couple things. I think what you're doing is definitely in the public interest. I don't think there's any argument there from anybody, so I think that's important. It's almost like this complex was designed to be one. And I've been in the insurance business for many years, and I've insured a lot of these places, and you start out with the developer, and he says, yeah, we're going to have this big complex. And then as things are moving along, to your point, somebody says, well, I just want to buy that one, I want to own it, and that's where I want to be. But they don't change the design of the complex because it's not necessary, because it was designed to be one. I don't know if that was the case here. Caroline could maybe add to that. This was built what year?
There were different buildings were built different times, so I don't have the run.
They just, when I drive in there, I looked at one complex. And that's one of the reasons why I went. It didn't stand out as, what is it, 3 or 4? When you show that overhead map.
There are 3.
The 3 buildings were built at the same time.
Well, no, I meant when you drive in the buildings to the right, that, the access road, I didn't see a big design difference between those 3.
These 3?
Yeah, those 3. I mean, maybe there is, but it didn't stand out to me as being noticeably different, which leads me to believe that it was designed as one complex. And I've looked at many plats and all this kind of stuff when you're doing this, because you got to make sure you're insuring the building properly. So that's why that's not unusual to see what happened there. I guess nobody really knows the reason why, but that's typical, I think. Where I'm in an office complex, and we just have little condos, and that's, one big complex, one owner. Nobody offered to buy one big building and subdivide it, would be my guess. It is a little unusual, though, that who maintains the pipe stream as far as mowing, grass, that kind of stuff?
So it's part of I haven't read this entire Declaration of Covenants, Conditions, and Restrictions for the corporate center, but based on this plan here, the cross-hatching means it's included in common area, and so basically I'm surmising that there's a mini there's control, there's
I mean,
overall
somebody's got to
control.
mow it. And
Yeah,
and I
there's
assume
overall
the property
control.
manager's mowing it, or is it?
It's probably similar to a condominium regime where all the owners are part of this covenant. They all sign off on this
They
covenant.
contribute to the money that goes to then a central, management.
And then they hire
company
the
that-
snow
yeah,
and the
right.
tree.
Right.
Right, so essentially the complex is maintaining that, which again, even though it's subdivided 3 different ways, it was still designed to be one,
It-
in
it's
my
cer-
opinion,
It's certainly.
with the road.
Right. They are not standalone properties that are completely free of connection. They operate as a collective in some respects with access, probably parking. Again, I'm not familiar with all the details, but probably parking, maintenance of common
And I know
areas.
we're just doing hypothetical, but if just layman term, I'm a layman guy. Yeah, that's the bottom line here. And so that's how I try to look at this. The other thing is, to me, if whoever bought that or had it subsidized, they would have, if they didn't want to be part of the overall community, they'd have had to cut a road in to get to their building. You would think. I'm not sure. I didn't drive over there, but I thought so. So to me, I look at this as one big complex is where I'm going with it.
Okay, we agree.
And so, but on the other side of the coin, I think we need to be careful to assume the zoning laws are going to change. Because I think this is going to bring that to light, really. I think everybody's going to rethink that 75%. I personally think that's too much, but everybody's got an opinion. But is 25% too little? And so that's kind of my general comment right now. And the other thing is, one of the things I noticed is that there seems to be a lot of activity in the back of that building. On both back, you have a lot of tanks, and there was a generator on a trailer. Is that, when you do these improvements, is that going to be, for lack of a better word, tidied up? Are you going to
Absolutely.
need that trailer?
Absolutely. So what we're doing right now is we're studying the needs for infrastructure improvements, and we're carefully, calculating the size of the improvements and whether that counts towards lot coverage or counts towards parking. There's a whole analysis that will then go into a site plan amendment application, which we're hoping to file shortly, assuming things are approved tonight. But we're planning to, yes, tidy things up or address the overall site plan through an amendment with an application, hopefully very shortly.
For instance, that semi-trailer, is that a temporary thing?
Chad?
That is a temporary infrastructure piece because we have.
You gotta come and.
Sorry.
Out here, we can pick you up.
So that's a temporary HVAC infrastructure, because I noted in my testimony that we were having HVAC failures, which were impacting our drug discovery activities on the campus. So that goes away with the approval of this.
So these additions are going to add new HVAC to,
It gives us the opportunity to relocate some of the infrastructure that's inside the building to outside, and then rebuild some things that are on the inside.
and that will go to the roof, I guess, the new HVAC?
Some will go, no, that will all be internal, but I would turn that over to Brian, who could specifically answer location strategy for equipment.
It's fine. I just want to get a general idea. And then, my concern was, here you guys are a world organization, and I see a lot of stuff out there that's basically wide open to vandalism. And I'll tell you, I think without your tenant, your next door neighbor, I should say, you probably have some issues. There's a lot going on, and some of that stuff is valuable. And so hopefully, I wouldn't rely on your tenant being there forever, which happens to be the Montgomery County Police. What district is it?
I'm not sure.
Yeah, I think it's the German.
Six.
District
Six.
6, yeah. So there's plenty of police presence, so I don't think you're gonna have any issues, but, moving forward, you never know. So that's my comments for right now.
Okay, thank you, Gary. Dave, or should I, Robert?
Because mine will be short.
Okay, and then Dave. Okay, thanks, Robert.
But Gary, to answer you, I think they're moving the police right down the street, right next to the Wawa. That's what they're building down there, is the new police station. I do believe.
It's
isn't it?
Royal
Yeah.
Oh, Royal Farms.
Yeah, Royal Farms. That's where the new police station's gonna be.
So I guess
they're
you'll
gonna
lose your,
move.
will they lose your, can you confirm that? Have you heard, is the property developer or owner here? Okay, so we have, all right, so, but Robert's probably right, I think that's short-lived.
But that's what, I was just adding that in.
Yeah, no, thank you.
I appreciate your all's testimony, because it's enlightened a few things. But I just have one, question. There was one slide, on one of the pictures, a regular picture that showed the back where the wastewater treatment process, water generation was gonna be. Is that security fence, that's, what's behind there, or is that gonna be eliminated, and with what's behind there, and where is that gonna be moved to? Chad might be the one that,
I got it. So that, in this specific image, that's a utility shed. That all is part of what Mr. Young was referring to as part of activities in the back. That all gets cleaned up behind Building 45
Yeah.
as well.
yeah, when Gary mentioned that, I didn't know if that was the same thing I had in my notes here, because that was the one thing because that's exactly where the building's proposed to be. Is it?
Is that it?
Is it?
Can I just follow up on that question then? So if already we have sort of temporary structures where you're hoping to put permanent structures, is that accurate?
Semi, but not quite. So
Can
the-
you help me with just like the square footage of the temporary structures right now and
I
how
don't have the
different that
square
is
footage off the.
what you want to do?
How much?
The one, the little storage thing is
This-
96 square feet.
Uh-huh. Okay, so it isn't as significant as what? Okay.
Yeah.
Got
Well,
it.
just so, because I've been there.
Yeah.
There's a lot of fencing where they have stuff behind the fence.
Yeah, yeah.
And there is that little shed, which I would agree is very small. But then there's areas that they haven't had a chance to fence yet, that probably, that's more what I'm referencing.
Okay.
Yeah.
And that area, I believe, is what's behind the orange and white barricade that you're referring to.
Yeah.
And some of that is just pedestrian safety, so people don't walk into that, but it doesn't alleviate your concern with the vandalism, which is well taken.
Sorry.
That's okay. Dave?
Thank you, Madam Chair. First of all, Mr. Barr, Kilmer, Crum, thank you for the presentation. I am absolutely sympathetic to really everything that you want to accomplish, and that this is for cancer therapy. And that does, in one way, go towards answering part of the question about public interest, I think. But there's a number of areas to consider here. Before I get into those, I have a question for our city attorney, Frank. Is there a distinction between the word lot and property? Because there's a definition of lot in the Gettysburg Code, but the specific instructions that we're giving have to do with property. So is there a distinction between those two words?
Generally, in the context of an application, property is going to fall down to mean the lot in question. So in this case, it would generally mean the same thing.
All right, thank you. So just kind of going through the conditions, this does, it's clearly about, area requirements and aspects like that. It's not, I don't believe it's contrary to public interest, especially given what you're working on and the fact of the size of the addition that you're talking about. It wouldn't create any sort of visible blight, I don't believe. That brings us to, obviously, the peculiar conditions of the property, which I'll get to in a moment. And then there's the unnecessary hardship or practical difficulty. So I do want to ask you a few questions about that. Prior to now, you haven't felt a need for those additions, I assume, because you don't have them yet. What has changed?
Well, as the building is aged, The infrastructure needs have changed. I think sometimes buildings need to be addressed in terms of aging infrastructure or upgrades, and it just, unfortunately, it just so happens that given the nature of AstraZeneca's operations there, all the equipment on the roof, it's not possible to address that with improvements on the roof. It's not possible to address it with open air areas that don't count towards lot coverage. I mean, we've, again, gone through the analysis of all the alternatives. But what has changed, I think, is just aging infrastructure. Is that fair to say, Chad?
I was waiting for your answer.
Oh.
The science,
Maybe
typically,
strike
I guess the basis is the science has fundamentally changed.
Hmm.
So just a very, very abbreviated Cliff Notes version of cancer therapy. Radiation chemotherapy, 1950. We have now gone to targeted cell therapy or targeted ADC, antibody drug conjugates, where we identify specific cells and then deposit a chemical into those cells to kill them. Now the activities over Building 45 rely on something called CAR T, which is where we reprogram T cells specific. So we would take a patient, extract blood from them, rewrite their genetic code, reinsert that back into their body, where it would specifically target cancer cells. You cannot do that in the conventional labs that exist currently. That development in, let's say, probably 2017 is when we started going, 2015 is when we started going to ADCs, antibody drug conjugates. 2017-18 we started exploring CAR T. It's all over the news, everybody and their brothers talking about CAR T. We are very, very heavily invested in that, which is what's driving the urgency behind this. So this is our primary CAR T research and development location. So all of our clinical trial material will be coming out of 45.
Okay, thank you.
That's fundamentally what's changed.
Thank you. And stay for a moment because I follow
Okay.
on to that.
Don't ask me really specific science questions.
I wanted the science. If you're unable to build these additions, will that building still be able to function for the research purpose that it exists for today?
No.
All right, thank you. All right, so that brings me to the last key condition, which is the aspects of the property that have to be overcome. Before listening to your testimony, I didn't really understand what you were talking about with the pipestone. So I do appreciate all that testimony. And while you were talking, I went ahead and looked up the definition from the Gettysburg Code of a lot. And it has a whole section on frontage. That section on frontage does not say that it needs to have vehicular access, but it does talk about how every lot requires, in order to be a lot, frontage to a publicly maintained street. When I look at this, really fully understand what we're talking about now, and I see this pipe stem going off from property F all the way down, the only thing I can really think of is a gerrymandered voting district. It feels artificial, something that was created to meet the letter of the law, but not the spirit of it. Because of that construction, I can see the impact that you're talking about in your ability to build or not build within the existing 25% requirements. I don't feel that we can take into account that Gettysburg retool may change those requirements. That's something in the future and not under our purview. But sticking within the existing 25%, the artificial nature of how that was constructed just to meet the base requirement, the minimum requirement of lot frontage, does feel, I believe, that it creates a very peculiar, I can't say that word for some reason, peculiar impact. I think that's it. Thank you, Chair.
Okay, thank you. All right, I just have a few questions here, so thank you. So, so when did you start the planning process for these additional buildings? When was that, when did that process actually start? In coordinating with, I guess, the city?
So we first started looking at additions and infrastructure specific to Building 45 maybe 2.5, 3 years ago. And then as the project continued and we understood more of what we needed for utility capacity, that further highlighted the issues that we were having with restrictions on the space specific to the utility area. Then as the science evolved, we understood that we needed a clean ingress-egress for the patients, which then added some complicating factors. Initially, we thought we could remove a storage shed off of the back of 35 West Watkins Mill, again, looking at that entire lot size. But then with the additional complicating factors, that wasn't feasible. One thing that I did miss in my testimony that I would like to add really quick, when we start looking at the complexities and how far we went with options, we toyed with removing and rebuilding the HVAC and utility systems at 35 West Watkins Mill and overhead piping them across the parking lot to drop them into the building. But then we understood that without vertical support, we weren't going to be able to hold the weight. So I just wanted to add that, like the level of due diligence that we went through in this process has been relatively extraordinary. It's been painstaking for me to listen to my team explain all of the things that they've been working on for this.
Okay, so thank you.
Sure.
So this has been going on for about 2.5 years.
Correct.
So 2021, 2020?
2020.
2020, okay. So that's it for my questions for you right now. Thank you. I have additional questions, and I'm going to ask this to the city, to Caroline, so I can understand the pipe stem. So why was a pipe stem placed on this large property to begin with?
So if you go through the chronology of the subdivision plats, it was once one whole property, and over time subdivided and re-subdivided so that additional buildings could be built on the property. And just one thing that I don't think has been mentioned, and maybe it has, the entire Bennington Corporate Center is not owned by one property owner. There are multiple property owners, and Parcel F and Parcel E are not owned by the same owner, so I just wanted to make that point. Parcel F has the pipe stem because that building could not be built without it under our subdivision ordinance, because Parcel F needs to have street frontage, even though they are not using that for vehicular access. That's the requirement of the subdivision ordinance, which is a separate chapter from the zoning ordinance. If Parcel E was subsumed, or if Parcel F became part of Parcel E, that building could not have been built.
Okay.
So that's why it exists. It does have its vehicular access through another parcel, but that requirement that it have that street frontage is why that pipe stem exists. The use of the pipe stem, from staff position, is sort of irrelevant to its necessity under the subdivision ordinance.
Okay, so having lived in that area for 40 years and seeing actually even the creation of the corporate park there and what used to be there before that, when was West Watkins Mill Road actually built?
I don't have the history of that to tell you with any
Because
certainty.
It seems to me that coming off of Clopper Road, that was the only road that was there. I can remember probably 1995 that West Watkins Mill had some kind of access, because I used to go to the FedEx drop-off over there.
Yeah, I don't know the date it was built. I do know as part of this development, there was dedications for the West Watkins Mill Road to accommodate the construction of it.
Okay. I was just trying to get some better understanding of why that pipe stem went out to Clopper Road, and thinking perhaps that road, West Watkins Mill, didn't even exist at that time.
No, it existed.
It existed, okay, okay. Okay, so, all right. So without the pipe stem, could that property have been subdivided then?
Which property?
The Bennington Corporate Park.
Well, I mean, so one of our concerns was the argument that were it not for the pipe stem, that parcel E could have been in a larger parcel, because if the pipe stem did not need to be there, there's any number of different ways that any of those parcels could have been divided up, and I don't know that any of us could determine how that might have been divided. Even with the pipe stem, it could have been split up in multiple different ways, not split up at all. It could have all stayed as one parcel, and then the 25% lot coverage could have been applied to the whole thing. Unfortunately, our zoning ordinance in the I3 zone requires the 25% lot coverage per lot, not per subdivision. So that was what we needed to apply, what we need to apply to each lot and not to the overall center. So I don't know how to answer what the lots
Yeah.
would have been had it not been for the pipe stem.
Okay. Yeah, we have a lot of those questions, so.
Yeah.
Yeah, I mean, I would
Greg.
just add to that, right? End of the day, the city staff, when they're reviewing subdivision plats, aren't looking necessarily at the configuration as if how someone wants to configure their lot lines. We're just reviewing at the end of the day to confirm that it meets the subdivision ordinance and the zoning requirements under the zone.
Okay.
So again, I would assume when the staff, again, I wasn't here when this was done. I would assume when they reviewed it though, they reviewed it against the zoning requirements because again, the city doesn't approve illegal subdivisions that create non-conforming lots. So we would have reviewed it to confirm that it met the frontage requirements, the lot coverage requirements, open space requirements, whatever's in the zoning requirements that needed to be reviewed.
Okay. So,
And I would add that it's an assumption, because none of us were really here when this was done, but that parcel F was done that way so that they could build on it. If it was done in some other way, they couldn't build that building.
yeah.
And that square footage maybe would have been divided up some other way, but that's what gives the building in parcel F the ability to be there.
Indeed. That is correct, yeah. I was just thinking about where Winchell Engineering used to be, and there was like this long road to get in the back there. It's since disappeared, the building's gone and everything, but maybe that was a pipe stem too, I don't know. It's just a side comment, but by there. Okay, so then, I think we answered this question, but I just want to say, my question is, does a pipe stem have to also allow vehicular or pedestrian access?
You're asking?
Yeah, I guess.
No, it does not.
It does not, okay, all right. But it has to be, it's my understanding, it was put there to be in compliance with the zoning
With
regulations.
the subdivision ordinance.
Subdivision.
Right.
Thank you, at that time,
Right.
at what was there.
Right.
Okay, and so, we've been talking about like the holistic 25%, and as I was reviewing this case, it reminded me of the TDRs at the county level, the transferable development rights. That doesn't apply here, so we don't have that ability to really look at other pieces, other lots in the subdivision to accommodate the 25%. And that's just the way it is, unfortunately. It's the way I'm interpreting it there. Okay, because we're a municipality with our own zoning ordinances. Okay, so then, and this is a future question, so it may be a question for Chad, but does AstraZeneca have any future building plans for not talking about what we're at here now, but is there anything in the future?
There are active plans currently where there's one commercial manufacturing facility in Rockville that we are working to design and fit out for commercial manufacturing of the materials that would be coming out of Building 45.
Okay,
So that's ongoing, and then there's another property, and we just signed a lease, so I can talk about that, over 700 Progress Way, which is also complementary to Building 45 activities and Rockville facility. So that will be a warehouse holding raw materials for Building 45 and for Rockville primarily.
And 7 Progress Way, is that by the exit 12, by the Royal Farms?
It's by the new FedEx building. I
The
haven't
new
actually
FedEx
been there yet, but
Okay.
I don't even have keys for it personally.
It's the old,
IBM
used to be
site?
the IBM site, and
Okay.
it's now got 2 new buildings on
Oh,
it. and
that's
a Chick-fil-A
Progress
in
Way.
the front.
That's
and, yeah,
over at the Mayhem building.
Okay, that's Chick-fil-A.
Chick-fil-A is
Long
in front
line.
of the building.
So we're taking one of those buildings. So there's 2 buildings
Taking
on the
one of those.
property, and we're taking one.
Okay.
How many square feet roughly? Just
Oh, you would ask me that. I don't know off the top of my head. I wanted, if I had to guess, it's probably it's
225,000 square feet.
there you go.
well, and you're also gonna. Sounds like you're gonna have an opening next to you.
Apparently, it's news to me.
Yeah. Oh, no, it's you mean the police lot?
Yes.
Oh, that's been in the news.
Yeah, I know. That's what I mean. But they obviously they're
yeah.
doing what they're supposed to be doing, and not worried about the police
there you
or their next door neighbor.
It's actually very comforting to have them there.
I bet it is.
Yeah. Okay, thank you. Thank you, Gary. So now I want to ask a question to Stuart about the re-subdivision. And maybe you could just expand again on why that is not an alternative
Okay.
or something to consider also.
Okay, sure, fair enough. So in the course of analyzing all the options, that was included in the alternative approaches to addressing lot coverage, potentially, right? Because we're here on behalf of AstraZeneca. Alexandria Real Estate Equities is not here. They're a completely separate entity that owns this property and the adjoining property, or affiliates of ARE own those 2 properties. So we're not saying it's impossible. We're not suggesting that it cannot be done. What we are saying is that it's far more complicated and will delay the project, and again, to a lesser extent, it's more expensive, and then we'll have to be, I presume Alexandria will want to reverse things back if, and it is an if, Retail Gaithersburg does relieve the lot coverage limitation in the I3. So it's just more complicated, right? Because you then are re-subdividing 2 adjoining properties, taking part of one property and giving it to another, replatting those properties. But it's not that simple, because Alexandria then has to figure out whether it's inclined to do that, number 1. Number 2, does it have lender requirements that it has to respect? Does it have tenant requirements that it has to respect? Can it just declare to lenders and tenants that this is what we're doing without them opposing it? There's a process to figuring all that out. Assuming all that can be figured out, then there's this corporate center that controls access and parking and cross easements and what additional work is needed to address that type of thing. It's just again, I don't want to be facetious, but if we're looking at the 2 options, we've got a molehill and a mountain. And obviously, if we satisfy the standards for summiting both, we're going to choose the molehill approach. Re-subdivision, replatting, re-subdividing, replatting back in a year potentially is a mountain that we would prefer not to climb, given that we're here tonight asking for approval of the molehill approach.
Okay, thank you. Okay. That's it for my questions. Any additional questions? Follow up?
Just a quick. So
Sure.
let's just hypothetically, this is approved. When would you start this project?
We would submit an amendment to site plan application as soon as possible, conceivably within the next few days, business days, to get that process up and running. Because this request tonight is just strictly to address lot coverage in the I3. We still need to process and have the Planning Commission approve an amendment to final site plan, which then addresses the location of the proposed additions and all the standards that go into review of the site plan. If that's approved by the planning commission, then we would respectfully ask the city to help us get on an agenda as soon as possible. We would then work on permits.
Okay, thank you. Any other questions? Any other additional comments? Okay. So I'm going to call for a motion to close the record now.
I'll motion to close the record.
Second?
Second.
All in favor, say aye.
Aye.
Motion passes to close the record. So now we're going to have our board discussion, okay? So, anyone want to go ahead and start?
We don't need to go upstairs or anything,
Do we have any question for council? If not, we just stay here and discuss. Correct? Yeah. If we had a question like on something that was like a legal matter, then we ask for things. There's no reason to go
No,
into
just
closed session.
if you have a question on a legal issue, that's what we're here for. Getting advice from counsel in terms of closing the meeting does give you the right to do that. But actually, given a couple of the open meetings trainings the last couple of weeks, and one of the points I make is just because you can doesn't mean you have to, or even that it makes sense. And partly because unless there's some, and I won't use the word peculiarity because we're using it otherwise.
You said that very
But
clean.
I know, I
very
can't pronounce
carefully.
it.
But unless there is something perhaps of a confidential nature or of a concern that goes beyond simply the strict interpretation of the law, if the question is interpreting the law, there may be a value for everybody to see and understand
Yeah.
what's happening. Because at the end of the day, that's really what you're trying to do is apply variance law to what the application is. So, I mean, you do have the Open Meetings Act says you do have the right to do that, but I would say under the circumstances here, unless there's something triggering the need for a measure of confidentiality. I mean, we've been talking back and forth on legal advice anyway, in the hope that sometimes it's better that everybody understand why you're moving in a certain direction or not.
Did that answer your question?
Isn't it?
So, as going over the definition, the right one in the staff packet, that the variance definition, just to remind ourselves again that, this is what we're considering this evening, which is section 24-1 defines a variance as a modification only of the density, bulk, dimensional, or area requirements in the zoning law that is not contrary to the public interest and where owing the conditions peculiar to the property and not because of any action taken by the applicant, a literal enforcement of the zoning law would result in unnecessary hardship or practical difficulty as specified in the zoning law. So, I just wanted to bring that up.
Well, and I think that's the right place to start because
Okay.
that's what we are empowered to review. That's what we should be considering through this. And my line of questioning is very much related to the fact that I want this construction to happen, right? And yet I'm still wrestling with, and I'd love to hear other people's perspectives and tell me I'm wrong. I'm wrestling with the definition of the variance. I'm not convinced that the conditions are truly peculiar to the property. It feels like they're peculiar to properties that are near the property, right? And not this property itself. And even if they were peculiar to the property, that they are then causing the practical difficulty. And it feels to me that this is an exacting standard. You don't always see the term, a literal enforcement of the zoning law, right? It feels to me that it's saying like there truly needs to be something peculiar, something exceptional, to push us past a literal enforcement. And we're talking literal enforcement because we're talking a minor,
Yes.
right? So I come at this right now from the perspective of we just haven't met the standard I desperately want to, right? So I'd love to hear other people's perspectives on those same questions because I'm not convinced that we've met that standard.
So I've struggled with that exact thing. And before coming in here and listening to everything, I had no idea how possibly we were going to overcome that. The more I really consider it, this very artificial way of shoehorning in property F in order to make that a separate plot that could be built on, or maybe it was built on originally and then subdivided out so someone else could own it, possibly. Who knows? But it's a very artificial thing that was done there. And although it's not on that property, it affects that property. And this is not something that you see every day. I have seen pipe stems with road access.
Mm-hmm.
I can't recall having seen something like this before. I'm sure it exists, but it's not common enough that I'm thinking of one.
Yeah.
And to me, that is kind of the definition of, I can't say the word, abnormal. Which
Peculiar.
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 Okay, we got it.
I can't do it.
We know what you mean.
I can't do it. But I mean, it's the
If I
truly
could- yeah.
it's the truly abnormal nature of that pipe stem. If it had a road access, if it was anything other than just a way of getting a small frontage
Mm-hmm.
that had no other purpose other than to meet the base requirements of that regulation.
But you're back at something about the condition of the adjoining property, right? Which
affects the
makes
property.
right. So I'm just trying to understand where you're getting to where you're getting.
Yeah, no, that's exactly where I am, and I absolutely understand the argument that it's not something about this property itself,
Mm-hmm.
but I imagine that if a property abutted next to a straight wall mesa, right,
Mm-hmm. Mm-hmm.
that the existence of that straight wall mesa would affect what you could do on that property. So things directly abutting to a property can absolutely create conditions on that property.
Interesting.
Yeah.
I can maybe add to that as well. Can you put Exhibit 8 up on the, I think
That's
it's
8.
8.
That's 8.
Yeah, Exhibit 8. So, yeah, so as I look at this was the, and correct me if I'm wrong, Caroline, was what was basically the drawing, for lack of a better word, from an engineer or some sort of, that came up with the design of this property and what it was gonna be used for.
Well, this is a subdivision plat.
Well, it's a subdivision
Or,
plat.
I'm sorry, it's a concept plan.
Yeah, so concept, so the point is, the concept was to be one park. And just because it was, and again, if we were talking about a huge amount of variance here, that would certainly make a difference, but we're talking less, let's just say 1%.
So,
And
but if I can interject
Sure.
there, that is not, the percentages over
I'm
is not
not-
part of our
I
variance.
understand, I
Yeah.
understand.
Yeah.
But it also sways to me the peculiarity of the design of the property. Because if it was gonna be a massive addition on that side, I think that now, no. I think, so that's how I'm thinking about it. The size it's definitely not a part of it, but since it's a small amount. So as I look at that, and then the other, is there a stream to the right, on that pipe stream? I think there is, isn't there?
I don't think.
Stormwater facility.
I don't-
Stormwater.
I think the record is closed, so I'm
There-
not sure that we can.
Oh, I can't even ask the question. Okay, then that's fine, never mind.
From satellite pictures, it looks like there's an algae overgrown lake.
Yeah, that's right.
It's to have the conversation between the board members.
Oh, yeah, so
Okay, yeah.
I
Oh, so-
think,
so-
I think it's,
so-
I think that's like a stormwater, And I know this has changed over the years because I'm involved in a complex where I live, or where my office is, that, you know, the way this thing is set up, you know, property owners are responsible for streams, or not property owners, HOAs are responsible for streams, stormwater management. I mean, this stuff's very expensive to maintain. And they didn't even know it. All they're doing is buying a house, right? We're just buying a house. And I know that's changed. That's no longer the case, because in my neighborhood, I asked that. We do not own those retention ponds. That's a city government maintains that. And I know there's been, so that's why I think that was done that way. I think this was done in the 80s, that property line would have ran all the way up to that. That's just my personal opinion. I could, you know, nobody knows. And so that's why I'm willing to look at that. I think that's part of our, in my mind, you know, does it cause undue hardship on the community? I don't see it, what they're doing. And what's the other definition?
Would they have practical difficulty or hardship?
The tenant.
The applicant.
Yeah, and I think they've said that, and I believe them. I think speed to market's important. I'm a business guy, and that's a big deal. And so that's why, though I respect the city's alternate plan, I think, you know, because that's what they're supposed to do. And they did that. And one other thing I wanted to say is, probably come to me when I'm, so that's how I'm looking at that. That's why I think that this is not an unreasonable. Also, you know, there's a Board of Appeals for a reason. And I think that's our job, that's just my opinion, to take a look at some of these things and sometimes have to make a hard decision. And there's gray areas. You know, so one person might believe one, another person might believe the other, but that's why we're here. So, thank you.
Thank you, Gary. Robert, do you have any?
Have my marks on the paper?
Okay. So I'm
They've
going.
been answered.
So I'm going back to the variance definition, you know, and in considering everything we've heard here, it's very painful to see that it's less than 1%, but that's not part of the equation as far as following what the variance definition is and granting a variance. Granting a variance if we need to, if we decide that, or if we don't decide that. So, you know, and looking to say, okay, it's 25%, okay, they're up against the limit there. You know, anything over that requires a variance. If you want a variance, this is the definition of a variance definition here. And so I'm looking at the property saying, well, the pipe stem has to be there in order for the property to be subdivided. So you're not going to have so you have your lots within the subdivision. So all those rules ahead of time helped to create the area that we're looking at today also. So rules had to be followed for that too, even if it is that little piece of frontage on Clobber Road there. We don't know the reason why, but it was in compliance with something. So in looking at this variance definition, it's like, well, is this request in compliance within the definition itself? So we're looking at buildings that are critical for the continued research of a very dynamic research, probably, you know, have global impact right here in Gaithersburg, right down to 1,800 square feet. building
Point well taken.
in a parking lot of 75% asphalt, okay? So, I mean, it's a hard decision when I'm looking at that there, because we have to deal with what we have in front of us. It may change in the future. It might get smaller, who knows? I mean, it could get larger, that's the intention, or what we're hearing. But I still have to go back to and say, all right, if there's a way to go, the buildings, the reconfiguration, those air conditioners never work. You put the chillers on top, they freeze. You know, I can see some of that stuff on the roof. I mean, to me, that was burdensome. But the re-subdivision, the platting there, you know, that is also an option. And so that's where I'm looking at it and saying that I did not see the variance definition met within the case presented to us tonight, as dynamic as it was, as emotional as it was. You know, I'm very
I respect that,
familiar.
absolutely.
So that's where I'm looking at it, saying, is that a peculiar property? No, that's just the way it was. That it fit the standard at that time. There was a standard that property with the pipe stem fit there. The other items here, I have no comment. So. So, any other discussion? No, let me follow my sheet here because we need to vote. All right. Okay, so we have the board discussion. Okay, so we'll need to discuss then, I mean, to vote to approve or deny the application. And so we'll need a resolution either to approve or deny. And we'll need someone to do that, and then we'll.
Is that where you read this right here? I make a motion?
You can make a motion, and then the board members will understand what the motion is.
I just want to.
Oh, there it is.
Make
Oh.
a clarification. There is no draft resolution because I had no idea how this
Okay.
would come out and what the conversation would be, similar to last month's hearing. So there will be a resolution that includes your decision and all of the findings that are included will be included from your discussion at the next Board of Appeals meeting. So what we really need tonight is a motion to, I think you have draft language there for that, a motion to approve or deny and direct staff to draft a resolution that reflects the board's discussion.
Okay.
I'm ready.
You're ready? Okay.
I make a motion that the Board of Appeals grant the variance application BOA 966-2023 and direct staff to draft a resolution of approval that reflects the board's discussion.
And do I have a second?
I second it.
So because I'm going to be clear about this, so the motion is to grant the variance application, okay? All those in favor say aye, and I'm going to do a roll call, just if you don't mind. Dave?
Aye.
Aye.
Nay?
Nay.
Aye.
Okay, so the motion passes 3-2. 3 approval, 2 denial. Okay, thank you very much.
Thank you very much for all the time. I
Okay,
really
you're
appreciate it.
welcome. Okay. You're welcome. And so we voted, okay, so we're going to move to our next item on our agenda.
You guys don't want to stay?
Okay, so the next item on our agenda is we have a resolution, as Caroline had described, that it's BOA 9648-2023, and this was a request for a 234 square foot variance for the driveway expansion at 212 Sportsman Way, and we need to vote on this. And the resolution was in your packet. Do we need to vote? We have to approve the
Just need
resolution.
to make a
So Chair-
motion to approve the resolution,
Okay,
or if there are any changes anybody
Okay.
wants to make, you can
Yeah,
make any
Chair,
changes.
just to clarify, we've made the decision on this,
Yes.
we're just approving the language
Yeah,
of the
thank you.
resolution.
Right.
Yeah, that
Okay.
is, you're right, and that's why I
The
was
in-
asking again too.
The intent is that the resolution capture what the elements are of your decision.
Thank you, Frank, yes. You got all that. So I'll need a motion.
I'll move that we approve of the draft resolution denying the application in BOA 96482023 as drafted and presented to the board.
Second?
Second.
All those in favor say aye.
Aye.
Opposed? Motion passes 5-0. All right. Anything from the staff?
No, thank you for being so thorough in the variance review. I think it was important to have everybody on the record, and you all gave me a lot of good information to include in a resolution, so I appreciate that. The next meeting, we'll have that resolution ready in advance for you to review, and that meeting is December 13th. At the moment, I don't believe there'll be anything else on the agenda, but you never know. But we will definitely be meeting to review the resolution from this variance.
Okay, thank you.
That's it. I don't know if
And-
anybody
and
else has anything
Frank?
else.
And Caroline, that'll be sent to them even in advance to make
Yeah.
sure we've caught
Right.
Yeah.
Yes.
everything, because there are a lot of elements and there was a lot of discussion,
Yes.
so that will take.
It's going to take some time.
Okay, so anything else, Frank or Greg? Jasmine? Anything else from the board this evening? Okay, this meeting is now adjourned.